Okay, good to go. So I'm going to call the meeting to order at 6:48. And I'd like everyone to rise and we'll say the Pledge of Allegiance. So I pledge allegiance to the flag
The flag
of the
of
United
the United
States of America
States
and to
and
the
to the
republic
republic
which it stands,
stands
one
one
nation
nation
under
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 God,
God,
indivisible,
indivisible,
and
with
liberty
liberty
and
and
justice
justice
for
for all.
for all. Okay. At this time, I'm going to ask for a nomination for the chair of the commission.
I'd like to make a nomination.
Go ahead, Guy.
I'd like to nominate Janine Becker.
Thank you, Guy. Do I have a second?
Second,
Thank you very much. Is there any discussion? First of all, Janine can't be here this evening. She had an emergency, was called away at the last minute. So I just want to put that out there. Is there any discussion?
Assume that whatever the role of the chairperson is, it's something she's more than qualified for.
Yes, I mean, Dan, do you want to give any more
Sure.
background on Janine?
Janine Becker is a attorney who's practices in Bridgeport for many years. Is a former president of the Bridgeport Bar Association. Has done a lot of her practices in both foreclosure and summary process, landlord-tenant law, and she's very well qualified.
Okay, any more questions? Okay, we'll bring that to a vote. All in favor of Janine as chair, please say yes.
I.
Yes.
Anyone?
yes,
Thank you. Anyone opposed? Any abstentions? Okay, good. So Janine is now the chair. And normally Janine would take over this role that I'm doing right now, but since she's not here, we're going to go and now ask for nominations for vice chair of the commission.
I'd like to nominate Kent Lewis for vice chair.
Okay, Guy nominates Kent Lewis as vice chair. Do I have a second for that?
second,
Okay, thank you. Did you get that, Cindy? Okay, good. Kent, do you want to say anything or to the commission?
I guess I don't know. I'm a housing consultant. I primarily work on affordable and moderate income housing. We both represent mostly owners and landlords and things like that in development of activities. But we also have to, go by the, what the requirements are with HUD and the other funding sources with CHFA or the Department of Housing or whatever. So I'm very familiar with, obviously, with housing and rental housing in the state of Connecticut. Not much in Trumbull over the years. We have done a little bit, but not very much. But that's kind of wasn't expecting that I was going to have to deal with the agenda today. Because I just found out about this a couple hours ago, but that's okay. So.
The metal is being tested, Ken.
Yeah, right.
Well, we thank you for stepping up. You never know anymore what happens. So emergencies unfortunately always just seem to crop up here and there. So we do appreciate you stepping up and doing that tonight. Any more questions for Kent? Anything else about the vice chair's role? Okay, well then we'll bring this to a vote. All in favor of Kent Lewis as vice chair, please signify by saying yes.
yes,
Yes.
Anyone opposed? Any abstentions? Okay, great. So Kent, you are now vice chair, and I turn over this meeting to your capable hands. Thank you.
I don't even know what I'm looking at the agenda that I have. FOIA overview? Is that just giving an overview of what the fair rent commission
Let
is
me
gonna be?
just step in 1 minute. Best, I think, let's introduce everybody, give everyone a chance to introduce themselves so everyone knows who's on the commission here tonight. Okay, and then I'll step away.
I'm Jim Zigmont. I own Zig Computer Consulting here in town. I work with about 9 different housing authorities from their technology infrastructure, Trumbull Housing being one of them, Westport, Weathersfield, West Hartford, Danbury, Newington, Ellington. I may have forgotten a couple. So I'm familiar with housing from that perspective, and I've been in several key planning meetings when it comes to housing.
I'm Guy Rocco. I own Atlas Appraisal in here in Trumbull. I've also had some experience working with the Norwalk Housing Authority. Most of the time I deal with residential real estate appraisals.
Okay, I'm Rose Bodies. I'm former town clerk of Trumbull and assistant town clerk in Norwalk for 8 years. I also have had my real estate license since 1986 and familiar with the market.
Lisa Valenti, licensed realtor since 2008 and have experience with landlords as well as tenants.
Left. Just for the other people here, I'm Dan Shopik, the town attorney. Who else is here? Michelle?
Hi, I'm Michelle Jacob. I'm the Director of Human Services for the town of Trumbull.
Rena Baclar, Director of Economic and Community Development for the town of Trumbull.
I'm Cindy Kapsky, Chief Administrative Officer. I'm going to probably end up with the clerking duties and be the one to communicate with all of you if anything arises.
I'm Rob Labrandy. I'm the town planner of Trumbull, and I'm also luckily the fair housing officer.
Anybody else?
I'm Sarah White. I'm an attorney at the Connecticut Fair Housing Center. I'm here along with Rafi Podolsky just to talk about fair rent commissions.
Hi, I'm Rafi Podolsky. I'm an attorney with Connecticut Legal Services and a housing policy advocate for legal aid programs in Connecticut. And with Sarah, I was also involved in the adoption of the legislation that has forced this fair rent commission on the town of Trumbull. So, and actually, for whatever it's worth, in the early 1980s, I was a member of the Hartford Fair Rent Commission and have some actual hands-on experience with the handling of cases by a fair rent commission. And actually, I also want to say I'm honored to be here for this opening meeting, and I'm having heard the introductions of people, I'm actually very pleased. This is going to make for an interesting conversation.
Okay, I was the next thing on the agenda is there's an FOI overview, but I think we can save that for afterwards. I would just my own introduction for Sarah and Rafi. They have been unstinting in their generosity around the state in making these presentations to fair rent commissions, and we thank them. I know you've done presentations for CCM, I think for CAMA, and so we look forward to what you have to say tonight. Go.
All right, are we ready to start? Or so what we were going to do is begin with a PowerPoint, just kind of giving an overview of the law around fair rent commissions, how fair rent commissions work in practice, how decisions are made, but then spend the majority of our time really just having a conversation, question and answer. So you all can ask questions, we can give our feedback. Some of the things around fair rent commissions are ambiguous, or there's multiple ways to do things, and that is potentially part of the fun of it. Rafe, is there anything you want to share while I'm trying to get my PowerPoint up?
Well, I just want to say one thing, because I'm really fascinated by okay, well, let me talk while the PowerPoint's coming up. I'm really fascinated by the backgrounds that people have described as they introduce themselves. And so one of the things when it gets to be my turn to participate in the presentation is I want to try and pull you a bit out of your professions. And that's because fair rent commissions are meant to be commissions of members of the community, not experts, not professionals in the field, but experts in the community. Because a lot of what you're going to be doing is applying good conscience. And so I hope when the time comes, you'll be able to, while you'll have very important knowledge from the real estate field or the appraisal field or any of those fields, that's obviously important knowledge, and I don't want to minimize it. But I hope you will see that there's it's sort of a different role that you'll be playing as distinct from your professional role. So I'll stop with that for now. I think Sarah and I haven't quite worked out who's doing which pieces of the PowerPoint, but Sarah's going to start, and we'll
just go back and forth. So what are fair rent commissions? So they've been around since 1969. Although, you know, obviously the law changed recently with requiring them for towns with 25,000 populations or more. Previously, they were just permissible. And essentially, the Fair Rent Commission is a municipal board with the power to limit or modify rent increases and other rental charges. So it's not just rent increases, it's rent in general. So as to prevent them from being so excessive that they're harsh and unconscionable. And that's the language that's used in the statute. And the origin of Fair Rent Commissions was really a time quite similar to our own, where tenants were experiencing very large rent increases, sometimes in properties that were not very well maintained, or dealing with you know, sometimes unsafe, unsanitary conditions in housing. And the Fair Rent Commission was intended as a tool to sort of address both of those, to give tenants a way to deal with conditions and, you know, excessive rent, whether that's because the conditions are not good in a property, or, you know, the rent increase is too much for that tenant, or given, you know, the state of an apartment. The reality is that without a fair rent commission, there really is not a practical way for tenants to challenge unfair rent increases, no matter how large they are. So they serve an incredibly important critical function. And like Rafi was saying, are really intended to be kind of the conscience of the community regarding rental charges and increases. And, you know, commissioners are just ordinary members of a community. Do you want to go next, Rafi?
Okay. What else does the Fair Rent Commission do? You know, people think of the Fair Rent Commission as dealing with rent increases, which is a primary function for commissions, but it can also hook itself into code enforcement. This may be less of an issue in a town like Trumbull, say, than it would be in Bridgeport, but certainly one common action of the Fair Rent Commission where there has been code inspection of the property and it's non-compliant would be to delay or reduce the rental increase until there is compliance. And so it becomes a way of backing up a code enforcement agency. So that's sort of a secondary, I would call it a secondary function. The other thing that I think is really important is a lot of landlord-tenant disputes that are related to rent are disputes because the parties don't talk to each other. And it can be very difficult for those conversations to happen. A Fair Rent Commission effectively brings third-party intervention. And it's very common that whatever staff member at the municipality is handling complaints as they come in, by simply generating communication through that person, through the staff person, between the two parties, you actually end up with what's essentially a mediated solution. And there never is a hearing before the Fair Rent Commission because these issues have been worked out. The best example I can give you is a tenant who comes in and says, if the landlord would just fix these things, I wouldn't mind the rent increase. but they don't talk to each other. The conversation results in the thing being fixed and the tenant withdrawing the complaint. I mean, that's one of many possible resolutions that can happen, but that's not an uncommon thing. And that could not happen in the absence of a town having a body through which that conversation can take place. Shall I approach that? We're going to do one page each. Sarah, why don't I go back to you for the next page?
So what are fair rent commissions for? So fair rent commissions are intended to provide essentially individualized rent stabilization to tenants who already live in an apartment based on that tenant's complaint about unfair rent increases, bad conditions, or reductions in services. So rent is unfair given rats, mold, broken elevator, some examples I've seen, and also tenant complaints about landlord retaliation. I think that rent stabilization piece is key. I think there's a popular conception, kind of a misconception, that fair rent commissions are just intended to make sure that the rent a landlord charges is in line with the market, but really their mandate and purpose is much broader to that. If you look back at when the statute was first passed, it was to ensure that tenants, themselves can remain in place, when possible. So a rent increase might be unfair because of its impact on that tenant, even if it is sort of in line with the market. So it is this like individualized rent stabilization. Under state law, any tenant can complain about, their rent or rent increase unless they live in a seasonal rental. And then the general process is the tenant complains, usually a fairly simple form. Often there's informal conciliation by the town to see whether agreement can be reached, possibly an investigation, which could involve housing, health, building code, fire inspectors, the hearing, and then a decision, which is usually reached at the hearing.
So let me say something about the kind of decisions that typically arise. The commission has the power that, maybe I should just say this, the commission's a municipal board, and you as commissioners and acting as a group have the powers that a municipal board has. So it's not you're not an advisory body, you're a decision-making body. And in some sense, it's quasi-judicial because it's essentially you're hearing a dispute between the landlord and the tenant, and you will end up hearing from both sides. We'll come to the section on the standards that are applied, but in terms of decisions, commonly you could have a situation where the commission simply says no increase. You could have a situation where the commission delays the increase or staggers it, says, for example, that it needs to be phased in. You could have the increase, you could have either all of it or a portion of it, but you don't get it, but not all at once, because it is so large an increase that it creates an untenable situation for the tenant. You could have a rent reduction under certain circumstances, but that's usually where the property itself is in pretty bad condition. There can be a conditional a decision that things will happen when certain conditions are met, or obviously the commission can allow the rent to go forward, and essentially the tenant loses the complaint. And also you have the power to prevent retaliation, particularly against the tenant because they filed a rent increase. A landlord cannot, for example, evict a tenant for no cause because the tenant has filed an application with the Fair Rent Commission. That would obviously undermine the ability of the commission to handle any complaints, to receive complaints.
So what can
go ahead, I'm sorry.
Go ahead, Rafi, go ahead.
I said, okay, I like this one, so I want to say something about it. The statute lists 13, I think it calls them circumstances, that the commission is supposed to consider as applicable. And the commission can consider other things as well if they're relevant and applicable. And we kind of group them. If you've, I'm hoping you've read the statute. But if you look at it, it has a certain quaintness to it because it talks about, well, it just uses terminology from 1969. But we've tried to group them into what seem to be the most substantial things that commissions look at. They'll look at the size and history of rent increases. So it makes a difference if this is a $10 increase or a $100 increase. They're looking at the operating costs. That makes a difference if the landlord is would lose money without the increase versus making a substantial profit. They'll look at the tenant's income and availability of alternative housing, which is what is the impact of this rental, these rental charges on the tenant, and is there someplace else the tenant could find to live? They'll consider the condition of the apartment and the complex as a whole, the whole premises that are being rented by the tenant, and that particularly becomes important where the premises are significantly substandard. That may make a big difference. They'll consider what's included in the rent, like are utilities included or not? Is heat included or not? And they will consider comparable rents in the neighborhood and in the town. But I want to put a footnote on that when I say it, because it's important to recognize that we're looking, first of all, that's one of the factors, but it's not the only factor. So the fact that a rent increase is within market, as was mentioned earlier, does not mean that therefore the tenant will automatically lose the complaint, because there are these other factors to consider as well. The commission's job is to use its judgment to balance those in what it deems to be an appropriate and fair way to reach a decision. That's really what your job becomes. The other thing is, when we think about comparable rents, we tend to think about what a rent would be to a new tenant moving into a new unit. But the Fair Rent Commission is about the impact of the rent on the existing tenant in the existing unit. So you will find situations all the time in which a long-term tenant who's paying a sub-market rent, the building is bought by a new landlord who knows full well in the purchase what the rents are and who's in there, presumably that's part of the purchase process, who immediately says, I want the rent to be full market rent, and comes in and immediately jumps the rent. That's not uncommon. And so the comparable rents are relevant, but they are not necessarily conclusive, because that is contrary to the very purpose of the statute, which is to try and make it unnecessary as much as possible for a tenant to have to move because of rent increases. Okay, Sarah, back to you now.
So just a little bit about Fair Rent Commission complaints in practice, and some of this will be up to the town about, how you all want this to look, have decided for this to look, but in general, the tenant files a complaint, the landlord and the tenant will both get notice and information about the process. Typically also saying that the last agreed upon rent will be paid in the interim. And, often it's good to provide examples of prohibited retaliation. So everyone from the start of the complaint has an understanding of the process and sort of the expectations around rent and what should and should not happen. If appropriate, staff may be able to arrange for a housing code, health code inspections, other inspections if there's issues with conditions. There may be an attempt to conciliate the complaint, which often can just be a phone call, seeing what the tenant is looking for, what the landlord is willing to do, and seeing if an agreement can be reached, in which case can be put into writing, and that's the end of the complaint. Fair Rent Commissions also have the power to consolidate similar or overlapping complaints in the same complex or against the same landlord for a hearing. That can really make it more efficient if you have a situation where, say, a new landlord has come in, bought up a property, raised everyone's rent, a bunch of people have come to the Fair Rent Commission with a complaint. You can hear those cases together, issue either a joint or individual orders, so it's more efficient for everybody involved. And then, let's see. Here's some more about the hearing. Reefy, do you want to do this, or should I keep going?
You can keep going. Let me have the last 2 pages.
Okay. So the way the hearings are operated can be flexible as well. In some towns, commissioners get copies of any evidence that's submitted before the hearing. So things like housing inspection reports, a copy of the complaint, so everyone kind of knows what they're going into, which I think does make it helpful. The chair runs the hearing, swears in the parties and witnesses. Interpretation should be provided to anyone with limited English proficiency, which could be like telephonic interpretation through a service like Language Line. Often town staff or the town attorney are on hand to provide guidance to the commission during the hearings. And there's different ways to run the hearing. One way is sort of like a court case where, each side gives an opening statement, has their witnesses, can cross-examine witnesses. Another way we've seen is that after the opening statements, the commissioners ask the questions, and then give the parties a chance to either ask questions or, instruct the commissioners to ask questions. There's different ways that it can be done to sort of keep things orderly and, recognize that sometimes there will be situations where the tenant may not have an attorney, the landlord may have an attorney, and try to take that into account in terms of how it's structured to make the process fair for everyone involved. Typically at the end of hearing the evidence or hearing all of the cases that are scheduled for that hearing, the commissioners deliberate. That is a public deliberation, and then come to a decision and deliver typically an oral decision at the hearing. If more time is needed, that can be done, but the norm for most commissions is that a decision is reached. Almost always that decision is unanimous from what I've seen and heard from Rafi about past commissions as well. And then after the hearing, usually staff will write up the decision, get approval from the chairs and the commission, and then send it to the parties.
Just as a footnote to that last page, I don't want to overstate that decisions are often unanimous. They are, but they're not always unanimous. And people, nobody's required. You don't need a unanimous decision to decide a case. My experience has been that there is sort of a common communal sense as to what's fair and reasonable and what's not fair and reasonable. And that crosses over the divide between landlords and tenants, and that it often turns out that there's a consensus. And in fact, one of the things I've seen is that sometimes when mediation doesn't produce an agreement, and the case goes to hearing before the commission itself figures out what would have been a reasonable agreement if the parties had just agreed to it, and that ends up turning out to be the orders of the commission, something that sort of a third party observer could have said, this is where the parties should have gotten there on their own. This is really, the last 2 pages are just really for your information. Prior to the passage of Public Act 22-30, there were 25 towns that had fair rent commissions, most of them going back 30 or 40 years. Not all, some relatively newer, but a lot of them were older. Interestingly enough, the commissions were not where you would think they would be. You would say, well, it must be Hartford and New Haven and Stamford and all the other big cities. But if you look at this list, you will see of the towns without an asterisk, the ones that already had a commission. I just want you to note Newington. Let's see what else we've got here. Simsbury, Rocky Hill, West Hartford, many of the towns that are close to, particularly close to Hartford. Hamden was one of the towns close to New Haven. Bridgeport was one of the early commissions. The Bridgeport allowed their commission to essentially become dormant. It's now reactivating that commission under the statute because it has to have one, but it actually had one. So that Trumbull, although it's a suburban town, is not out of place when you look at the places that had a commission before 2022. And so this is a list to let you see the ones that now exist. And it's also interesting to note on that right-hand column that there are a bunch of towns that are smaller than 25,000, all of which are pre-2022 towns, but all of which have had fair rent commissions, most of them for years. Killingworth is pretty new, but almost all the rest are at least 20 years old. Go ahead to the last page. And here, all that we did was we arranged them by region, so you could see where else fair rent commissions are. Note that Lower Fairfield County has a number of new fair rent commissions. In contrast, say, to Greater Hartford, where most of the commissions are older commissions. And Greater Bridgeport has, with except for Bridgeport, has all new commissions, and Bridgeport effectively has a new commission because its commission had been dormant. So you are a piece of the state that is a little bit unusual in the extent to which the commissions are new. But so we're now up to 52 commissions, and it's our hope that some of these commissions will ultimately be in touch with each other, and in the sense that you can learn from each other. I think with that said, am I right, Sarah? We're ready to contact information. If you want to be in touch with us, either of us, there we are. The our goal here, we've run some other workshops. This is actually our 4th workshop. And we've run some, well, actually, we've run more than 4 workshops because we've done some with individual fair rent commissions. From here, we just want to go ahead with question and answer. So we'll stop, Sarah and I will stop talking, and we will try and respond to whatever you have. We've put out, I mean, apart from the PowerPoint, which you can have a copy of, we put together back in January, actually also before that, but a toolkit, which can be, I don't know if, have you seen the toolkit?
I just put it in the chat.
Oh, okay. Well, and that has a lot of questions and answers that you can look at it, at your leisure. And so, okay, I'm going to stop talking. We're open to whatever you want to talk about. So please feel free to go ahead.
This is Cindy Katsky. I just wanted to point out that I had sent the toolkit to all of the applicants at the time that they were, applying for appointment to the commissions. So, and I think they all did a good job reading through it. So
Okay.
I think they've seen it.
It's my understanding that the commission would gather for a meeting based on someone putting an application in to the town. I'm assuming to the town that they feel like they're being unfairly treated when it comes to paying rent. Does that process begin at the town level? Does the chair, our chair or vice chair, get the application and then call a meeting? How exactly do we lay dormant until someone has a complaint or a concern with their rent situation?
Correct. So typically the complaint goes to the town. It's dealt with by town staff. I don't know who exactly, but you all can obviously, folks on this call can obviously answer. The commission would only get involved if it's not resolved and gets scheduled for a hearing. So, and then, at that point, you probably get a copy of the complaint, the information that's been gathered, but you're not involved in the process typically until there is a hearing scheduled and like at the actual hearing.
It's, I think every commission is different, and some of it's driven by how many complaints you're going to get. So, for example, in Hartford, the commission has a regular monthly meeting. And I think it can do that because it's always has at least one complaint and may have multiple complaints. I think in smaller towns, in places that have perhaps less dense rental situations, complaints don't come in very often. And so the commission is essentially going to meet on call. And the commission, presumably Trumbull will, someone who works for the town of Trumbull will get designated as the staff person who's going to actually receive the complaint. So if they come in to town hall, they're going to be given to somebody in the town, and that person is going to initiate the internal process. And you'll want to do that right away because you don't want to have a situation in which these cases drag on a long time. I mean, that creates sort of an unfair situation for both the landlord and the tenant if they're left hanging. So typically you want to have a hearing. If there's going to be a hearing, you'd like to have that hearing, say, within a month, maybe less. You'd like that process to begin where you might have a means of communication between the landlord and tenant to start as quickly as you can, because you may get a resolution within a few days. I mean, you don't know. You don't know until you start to see whether there's room for compromise or not room for compromise. So you want that process to move quickly. If there are complaints, for example, about the condition of the property, then you're going to want to get someone from code enforcement, whatever is the appropriate part of Trumbull's code enforcement system, out there to take a look. So you need to give them time to get out there, to get back, to give you a report. So you don't want to drag the situation out from month to month. You want it done quickly and back to you quickly. And so you may want to schedule a hearing date basically as soon as you get the complaint. Possibly even before that could even be part of the first notice that says, if at the same time you're sort of reaching out to the two parties to also say, this is when the hearing is going to be if we haven't resolved it before then, so that you have a fairly fixed clock. You'll figure this out yourself, as I think, as you start to get some complaints. But I think that's this is something where it's really in people's interest to try to move it along as best you can. Normally, a hearing on a rent case would never take more than one meeting. It can happen, and especially if it turns out there are multiple tenants complaining about multiple things. But ideally, you want the hearing to be handled in one day for a couple practical reasons for you and for them. You don't want people to have to come back a second time. You don't want to forget what the testimony was a month ago at a hearing or 2 weeks ago at a hearing. You want to decide this while it's fresh in your mind. And you don't want to have the problem of what happens if you continue this to another day because you didn't get done, that now at your new date, it's not all the same commission members who come back. So now you have to have a system for the commission members to find out what happened at the preceding meeting. When you can do everything in one day, it's all done, it's fresh in your mind, you make your decision and you can move on. Some commissions will never have more than one hearing in a day. Other commissions may schedule more than one hearing for a particular meeting.
Is there a code of conduct or decorum or any way that the meeting should be run in a particular manner if there's a conflict of interest, Robert's Rule of Order, so that we can get to a swift decision, a fair decision if it comes to that? I'm assuming the chair and the vice chair would control the meeting from that perspective. Is there anything that we need to read up on that the town may have as to how these type of meetings or hearings are run?
So, well, okay. First of all, it's helpful for the presiding officers to think about in advance. I mean, you're gonna end up doing stuff by trial and error, but it's like, in a broad sense, it's like any other municipal board that holds hearings. You're going to want to have an orderly process. This is not the kind of public hearing at which the public gets to simply speak the way it might be if you were doing a sort of a quasi-legislative role. This is a hearing in which there's a complaining party and a responding party. And so you want to have you want to be in a situation where you can call on people and they can testify under oath. You're going to swear them in, and you have a system to it. So I think you would run the meeting. It's helpful if somebody knows Robert's Rules of Order. You don't have to operate under Robert's rules, but it makes sense to know what a motion is, to know only one person speaks at a time, to know that the audience is an audience. It's not that they're not participating in the hearing or the meeting. If they're going to be in the hearing, somebody's got to call them as a witness. And so this is not going to be put to a vote of the people in the room as to what they think is the best decision. You're going to decide this. It's going to be your decision, not their decision. So in that sense, you want it to be orderly, but you don't want it to be. This is not a court. You're not under court rules. You're not under under judicial rules of admissibility of evidence. You can be far more liberal. You may well have people without a lawyer on both sides. It's much more common for the landlord to have a lawyer and much less common for the tenant to have a lawyer. And as Sarah indicated, that influences the way you run things. In some ways, the way, even if this was a courtroom, a judge is a little more tolerant of a litigant who's there without a lawyer if the other side has a lawyer. But it could be either way here. You could have a tenant with a lawyer and a landlord without one. You want to make sure that each party has a fair opportunity to present their case. And sometimes the parties, either or both of the parties, don't understand what it is you want from them. I mean, they don't know what's relevant evidence, for example. They don't know what's relevant to your job, where the more hearings you have, the more clear it will become to you as to what's the information that you most need from them. So you're going to want to give them enough room to tell initially, the tenant would presumably go first because the tenant's the complainant. So the first thing is, tell us why you think we should do something and what it is you want us to do. You're in a position then to ask them questions. You can allow the landlord to ask them questions. Then it becomes the landlord's turn to say, well, did you think, your increase is okay? And, what's your reasoning? Either party may have relevant evidence to offer to you, in which case they can offer it. Commissions have never required, for example, an appraisal. On the other hand, doesn't mean somebody can't come in with the real estate agent to say what the rents are in other apartments, but then you have to really carefully address the issue of comparables, because it's really hard to match comparables to other apartments. Again, if for no other reason, apart from trying to decide whether they're really similar, to recognize that the situation for an existing renter in terms of rents may well be different from a new renter, because it's so common for new rents to be higher than existing rents. And that's not, you got to make the right comparison. But again, it's one of many factors. But all of those things somebody can bring in. They can, hopefully, if there's been a code inspection report, you will either you will have the code inspector there, or you will try and see if there's ways you can get it sort of brought in before you without the inspector being there. But if the parties need to be able to question the inspector. And so if you may need to work something out with your code enforcement agency in some cases where that may be relevant. I don't know if that's.
Can I just interject something for a minute on a procedural update? This is Dan Shopik. FOI rules require that in a Zoom meeting that anybody who speaks identify himself or herself. So those questions came from Jim Zigmont, but anybody else, as you come up, if you're asking questions, please identify yourselves. We skipped the FOI overview at the beginning, and I apologize. But at a Zoom meeting, right? These are rules with regard to Zoom meeting, and that's what we got.
This is Sarah White again. I just want to emphasize two things Rafi said. I think you do have a lot of flexibility in how you run it, and I think that that means you can ask questions of both parties and of witnesses, and don't have to just sort of passively listen to kind of what's happening the way a judge might in some kind of court cases. And I think that can be helpful, especially if you're dealing with one side that doesn't have a lawyer and the other side that doesn't, no matter who that is. And then on the Roberts Rules questions, I think particularly in terms of your deliberation and coming to a decision, Roberts Rules can be really helpful. Someone can make a motion, someone can, I'll be honest, I don't know all of Robert's rules, amend the motion, make changes to it, things like that, so that you all come to a decision in an orderly way.
I have a question, Guy Rocco. Are the rental cases that we'll be dealing with a combination of market-based rents that are typically MLS rentals, as well as public housing and Section 8 voucher rentals? Or are there certain ones that are off the table because they're controlled by a housing authority or HUD?
You're going to be dealing primarily with ordinary private market rentals. Section 8 or RAP are in fact private market rentals, and you have jurisdiction over them as well as any other private market rental. You can't change the statutory or the regulatory percentage of income that the tenant pays under those programs, because that's really governed by some other law. But you can control what the rent is. So for example, in Section 8, the Section 8 program does not control the landlord's rent. They control what portion of the tenant's income the tenant will pay. But if the rent is high enough, and if a landlord raises the rent up high enough, he could force a Section 8 tenant out by simply pricing the rent so high that the tenant could not possibly, they wouldn't be able to pay it. You're in the commission can look at that rent and determine whether it violates the standards of the statute. Public housing rents which is to say properties actually owned by the housing authority, as distinct from the fact the housing authority has sort of an administrative role in the Section 8 program. But those rents are going to be set by the housing authority under a regulatory process. But so that I don't think you would be in a position to change a housing authority rent. But
Right, I wouldn't think so.
But you could have a complaint come in, and I don't know that it'd be unusual, but you certainly could have it happen where someone complains essentially what is a code violation or maintenance complaint that has, in a sense, devalued the property, even from what they're paying, even though it's a subsidized property, because they're not receiving the kind of maintenance the law that requires. And in that case, you could take that, and you could be in a position to say, for example, we are going to authorize you're holding back payment of the rent until such time as the housing authority fix this. That becomes, again, probably less of a problem with Trumbull than in some of the bigger cities where there are real issues with housing authority maintenance of their own properties. And, hopefully that would not be an issue for you in Trumbull, and you would not be getting complaints out of housing authorities. But my view is your jurisdiction is very broad. And I'm going to volunteer something else on this, even though you haven't asked a question, because this issue has come up in other places, which is, can the landlord essentially take jurisdiction away from the commission by starting an eviction? And the answer is no. That the commission has a number of ways to deal with this. In some cases, it would be illegal for the landlord to start an eviction. It would be either a violation of Section 47A20 of the statutes, which is by statute within your jurisdiction to enforce. Sometimes it could be retaliatory on a motivational basis. It's doing it to teach the tenant a lesson. But you cannot give orders to a court. You have no authority to order a court, but you do have authority to order a landlord not to be retaliatory or not to do something that violates 47A20. And there's a provision in the statute by which you can issue cease and desist orders. So you're not removed from jurisdiction because there's a court action pending. On the other hand, your jurisdiction is limited to what you have jurisdiction over under the Fair Rent Commission statute. Ultimately, for example, it may have to be the court which enforces an order from you for the landlord to cease and desist from bringing a retaliatory eviction. You would want the court to know that you had issued the cease and desist order, but you can't tell the court that the court could choose to ignore your order if it wanted to. It's a different body, but that issue has come up before because it's not at all unheard of for landlords to essentially try to preempt the commission of its jurisdiction by bringing an eviction. And for a number of reasons, you can't let that happen because no one will file a complaint if they think that if they file a complaint, their landlord's going to evict them. So you have to be aware of that as a danger. And if the complaint's meritless, the tenant's going to lose the complaint. But that doesn't mean that they can get evicted because they filed a complaint. There has to be some other reason for the eviction.
This is Rena Backler, staff, not necessarily directly to the commission, but we get a lot of calls to our office, and Rob also.
Echo, Rena.
I don't know why, Dan, I'm sorry. But my question is, what if there's already an eviction underway?
I'm sorry, could somebody repeat the question?
I think the question is, what if there's an eviction already underway and the commission can still accept the complaint, adjudicate it? I mean, I would suggest going quickly so that the eviction doesn't resolve. I mean, Rafi, what do you think if there's an eviction already underway?
I believe the commission would take jurisdiction regardless. Some of this may depend on the reason for the eviction, But one of the things that we've learned is that it's clearer for the commission if the complaint has come in first and the eviction comes in afterwards, because then there's sort of an inherent suspicion that there's something retaliatory about this. But what happens in real life, I think, often, is that, first of all, the tenant doesn't know there's a fair rent commission and doesn't know that there's a possible remedy. The tenant may be disagreeing with the rent increase and say refusing to pay. And so the landlord starts an eviction because the tenant refuses to pay. The tenant then is told, go to the Fair Rent Commission. And they go. They never agreed to the rent increase. But now they've got a case pending against them. And let's just say that that's a case they would win. They would get a significant reduction in the rent increase. Well, they're entitled to have you hear that case and make that decision. If the court ultimately chooses to evict them, then so be it. But it's not take. You have a field. You have a specific area where you have jurisdiction, and the fact that there's a court action pending does not take that out of your jurisdiction.
I think another scenario,
to give a superior an order that takes precedence under certain.
Another scenario I've seen where this could come up is, this seems to happen a lot when there's a new landlord that comes in, is not fixing things, is raising rent. Tenants may have asked for things to be repaired. They're not being repaired. The landlord gives like a no fault eviction, starts an eviction case, and then they learn about the Fair Rent Commission, both to challenge a rent increase or to challenge conditions. There's a strong argument there too that, in addition to maybe disagreeing about the rental amount, that starting that eviction was retaliatory because it came after the tenant making requests for repairs, which would be another way for the commission to assert jurisdiction too. And another reason why it's important for the commission to take cases and all the way through, even if the tenant is coming to the commission after they've gotten a notice to quit or after even an eviction has started.
Hi, Lisa Valenti. I have a question, maybe perhaps for Rob, with the town. So we have a list, I assume, of people who have rental properties, a few multifamilies, auxiliary apartments. Have they been notified that this commission has been established? And have these homes been given certificate of occupancy that they're in compliance to kind of avoid any issues down the road?
So this is Rob. Go ahead. I was just gonna talk about the inspection process.
Okay, yeah, so this is Rob LeBrandy. So we do the unless somebody's coming in for if they have like a new apartment or a new structure, we'd CO it. After it's CO'd and given its building permit, we wouldn't go back into the property unless we received the complaint with the building department, or if there was, say, another illegal apartment, a potential apartment, we wouldn't, we'd go in there. Other than that, we would not go back into another apartment. But we do have a list of existing multifamily buildings that were or homes that were approved that we update on a yearly basis. So we do have a list. I think now that this commission's new and it's established, I think getting the word out is a good idea. So, but we are on top of the what we have in town, our inventory.
And just to add to that, Lisa, the fire marshal, any structure of more than three units, so it has to be considered commercial. So four units or more gets inspected annually by the fire marshal's office. That's not necessarily what you asked, because I think you're talking more about other conditions and so forth. But it is an opportunity for somebody to be in there, things that are dangerous and so forth. There are at least some eyes on it annually.
Rena, do you have speakers close to your laptop or your computer, your microphone?
I don't. I have nothing. I have no idea why it's echoing.
I have a question. you know, just being, you know, starting the ball rolling here and being kind of new to the process, is that what real authority do we have that maybe you could just direct me to of the of how we can require and figure out and enforce that a possible landlord must reduce their rental rate. I just don't, you know, if you could point me in the right direction. I just, that seems kind of, I don't know, funny to me that we're requiring that they, you know, that they may have to lower their rent. I don't know what the situations are with the landlords, if they bought the house too high or something, or, you know, now in Trumbull we have a really big need for housing, and I know during COVID the prices of rentals went up substantially in town, and I know the numbers of rentals that are vacant is very low, of housing units as well too. So I don't know if you could just point us in the direction of what we can enforce. I know it's probably in the PowerPoint, but what are the state statutes as well too that, you know, we could look up?
Well, the Fair Rent Commission statute, the statute number is Title VII, Section 148B is in baby, and then it goes, I think, through 148F. So we say 7-148B. So you certainly could look at the statute. The authority for the commission to be able to put a limit on rents is the statute. 7-148B is explicit, that says fair rent commissions can do that. So that's the legal authority to do that. And it's what makes your decisions binding and not just advisory to someone. The statute is also very clear that you have enforcement powers. So the parties essentially are bound by your decision, and it's an enforceable decision. You have the power, you'd have to hold an enforcement hearing basically, but you have the power to impose fines on them for violation. Your town attorney's office has the power to go to court to stop them, to enforce a cease and desist order, separate from, I mean, and you can have a cease and desist implicit in every decision you make that changes the rent or limits the rent, is the landlord is being told to do this and not charge more than that amount. If it turns out that he refuses to and insists to the tenant going forward that he's charging the full rent and it's not, and the tenant hasn't paid full rent, if he doesn't pay the amount that the commission said is the most he can charge, that's a statutory violation, and you have the power to enforce that. And you can use whatever means. Just as a town can enforce other kinds of orders that come from the municipality, you can enforce this.
Do you know off the top of your head what the fines are? I know for planning and zoning, it's dependent on residential or commercial.
I believe it's up to $100 per day. It's in the state statute. And just to be clear too, I mean, the commission wouldn't order rent to be lowered until they heard from both sides. And, you know, the landlord's operating costs, what they're making when put into this unit, are among the factors the commission can consider in deciding whether to lower rent. And I think is a reason why sometimes the commission, you know, commissions decide to do sort of staggered rent increases. So they do allow the rent increase to go forward, but do it, you know, $100 for the first 6 months, an additional $100 after that. I'm just making that up, but something like that. So it is less of an impact on the tenant, and they have time to try to, you know, come up with that additional income to be able to afford it. So there is a lot of flexibility to come up with the decisions that are fair to both sides and that, you know, reflect what the commission thinks should happen.
There's also a process for challenging a commission decision for both parties. The statute is explicit that both parties have a right of appeal to the Superior Court. In Trumbull, it would be the Bridgeport Housing Court. And either the landlord or the tenant could take an appeal. The reality is that a commission decision, the courts on appeal will back the decision of an administrative agency if it is reasonable based on the evidence that was taken. So that the court does not retry the case on a Fair Rent Commission appeal. If an appeal is taken, what the court will do is look to see if a rational Fair Rent Commission could reasonably have come to whatever decision they came to, even though they might have been able to come to a different decision and still would have been a rational, reasonable decision. Because the court is not retrying; it is checking to see that, number one, you followed basic procedures, and number two, so that everybody had their chance to be heard, and number two, that your decision was reasonable. Given that, your decision would be sustained on appeal, and because of that, there are not a lot of appeals of Fair Rent Commission decisions, because it's hard for either party to win a Fair Rent Commission decision, an appeal, unless the commission has made significant procedural defects that might be attackable as not having followed the proper procedures. But if it's going to the decision itself, the decision has to be kind of pretty wild for a court to say you went beyond the bounds of reason. I would expect a commission is not going to do that. And certainly I would be surprised if the group of you would make a decision that people could sort of characterize as almost irrational. So it's hard. So what you decide is going to be the decision. How long people have asked us, how long does the decision last? I didn't look at the Trumbull ordinance. A lot of the ordinances say how long it lasts. The statute does not say how long. My experience is typically a commission decision will be for a year, just because that parallels what most leases are for. It's possible to do it shorter. It's possible to do it longer. Longer would usually be done if you were doing some kind of a phase-in of an increase. But you could do the equivalent by only phasing in part of an increase. And then after a year, if people still object to whatever the landlord wants to do next, because he's no longer under an order, that you'd have to come back with a new complaint. When Sarah and I did a model ordinance, what we put in as our recommendation was that the ordinance should say that commission decisions are for a year unless the commission decides otherwise, so that you would always have the freedom to do a longer or a shorter period, but that in the absence of that, the default would be a year. What you don't want is like, and I've heard this, I've heard people say, oh, well, the commission made a decision, so that's only good for a month. So after a month, I can do whatever, the landlord can do whatever he wants. That's not a reasonable way to make decisions. You need some durational impact. And I think a year is actually quite reasonable.
I'd like
I have a question, Guy Rocco. When we make a decision, does it get filed anywhere in a legal sense, like at town hall, or where, we could be brought into a court case if it ended up in court? Or is it strictly just held in the Rent Commission's files and that's it?
Where do you put your plan? Where do you put your ZBA decisions?
Yeah, maybe I'll take that, Dan Shokik, the town attorney. The decision would first of all be part of the minutes of the meeting, so that they get posted on the town's website. And there are other areas where decisions, like right now, we don't have a link for decisions of the Fair Rent Commission, but certainly would be reasonable to do that. As was pointed out, there'd be an oral decision, and then that oral decision gets committed to a written decision. And at that point, it would make sense to post it on the website. It doesn't get published in the newspaper, right?
Right.
The land use decisions get posted in the newspaper, get reported in the newspaper. This doesn't. It's an open meeting. In fact, it's impermissible to have a closed hearing, so it's open to everybody, and in all likelihood, we've pretty much phased out these Zoom meetings, but it could be a Zoom meeting under Connecticut law. we could have a Zoom meeting. We basically met tonight by Zoom in deference to our presenters. So they didn't have to travel to Trumbull, although I know that they like to make use of the Connecticut highways. But in any event, that would be, and people have to show up, right? If we have a Zoom meeting like this, you could have 20 people picking it up on Zoom, because it's the notice on the website says that this is going to be a Zoom meeting, and anybody in town or anybody out of town basically can link in. Anyway, that's my long answer to a short question.
I think that for the parties involved, it's preferable to have meetings for it to be an in-person meeting. I don't know how well that works for the commission, but I think you will get a better sense of the parties. And for some parties, operating on Zoom can be very difficult. So, my personal recommendation would be that you try, if at all possible, to do commission hearings. A meeting like this, I don't think it matters so much, because you're not deciding cases and having parties. But a hearing on a complaint, I think everybody will be happier if you do it in person, so that everyone sees who everyone else is, and you will get a better sense as to the parties themselves, and it may have some influence on your decision as to how you approach things.
This is Rena Bachelard, Director of Economic and Community Development. We had a series of calls about a year and a half or 2 years ago, long prior to this Fair Rent Commission. And it had to do with a number of housing units where the affordability, it was a 20-year affordability, and it came off, and they jacked the rents up. And I mean like huge. I want to say like $1,000 a month or something. And families were being put out basically. So that can happen again because while our newer units are deed restricted for 40 years, we have some older inventory that is 20-year, 30-year thing. And boy, that time goes fast. And so how does the commission? So Rob and I are receiving those calls, and it's an affordability that's come up. Does this commission, and they may not be jacking the rent up over the market or anything, but if it's that drastic, have you seen that play out?
Yes. So just to summarize, because there was a little bit of echo for folks, Reno was sharing about situations where there's deed restricted or there's affordable housing, the affordability restrictions are lifting, and the new landlord or old landlord is in turn raising rent substantially. She was mentioning like up to like $1,000 extra a month. That is something that we've seen in other communities, in a place where fair rent commissions can be really helpful. Stanford, I know, has dealt with this with some of their properties, and tenants have filed fair rent commission complaints to address these large rent increases that are essentially driving them out of the complex. It goes back to looking at those factors and the sort of like function of fair rent commissions as the conscience of communities. Fair rent commissions really can be to provide sort of individualized rent stabilization, and even if the new rents the landlord is charging are legally allowed, are in line with what the market would bear, because of the impact on those tenants, their income, the lack of availability of other affordable housing for them to move to in the community, that can be a reason, after hearing, to decide to disallow the rent increase, to phase it in over time, to, for sort of whatever the commission thinks. So that is a situation where the commission can be incredibly useful, and really is the only possible venue like tenants have in that situation to deal with the end of affordability restrictions that can really significantly increase rent and really displace an entire building.
One of the things that becomes very relevant to, and this is a great example of a role the commission can play, is that the statutory factors, which are things that you're able to consider, it's important that you can weigh and balance them. So there may be some cases in which 1 or 2 or 3 of those factors becomes clearly to you so important that it really outweighs the other factors. And that's perfectly legitimate. the statute requires you to consider things, but it also gives you freedom to weigh. And so, for example, if you, the example that was being given, you have a previously deed restricted property or a restriction because of how it was initially funded. Now those restrictions are off. And what you see is a very, very large rent increase. You can say that even though some of the other factors would say an increase would be reasonable, even an increase to that amount, this is so unreasonable. It's not like you have to say, well, $1,000, okay, we can do 500 now and 500, or 500 in 6 months and another 500. You can say $100 now, $100 in 6 months. Then our decision ends, come back to us after 12 months, and we'll talk to you about, and you can, if the tenant wants to file another complaint, or you can say $50 and 50 and 50. I mean, you can make a balance that says something is so out of line for the particular factor, in that case, the size of the increase is so out of line and so disproportionate that it shocks your conscience. And you can implement that. Again, it's always, it hasn't actually surprised, I was gonna say it surprised me, but it actually hasn't surprised me. But I've always felt good that there's enough common feeling about these kind of things when you have a diverse commission, people coming from different points of view, that you may surprise yourself to discover that you all get kind of offended by the same sorts of things, and that it's easier to reach a consensus decision among the commission than you think it will be. Even though ultimately put it to a vote and it goes the way whatever the majority decides. But that's really an interesting example. And we've seen some of that, and that example of deed restrictions expiring is going to be happening more and more. There's been some newspaper articles about deed restrictions in federally funded programs where those are expiring, and it's been expressed nationally as a concern that there will be huge jumps in rent that will essentially drive out the people who were in the units that were affordable. And in the absence of a fair rent commission, there's no way to protect them. But a commission has the capacity in appropriate cases to provide a protection there and preserve that kind of affordability. But you have to have some justification for it. You can't just do it. I mean, you have to have reasons. And that's what you have a hearing for, to gather the information that you can base it on.
Thank you. Thank you.
This is Kent Lewis. I just wanted to mention one other thing, and I don't know if some of we keep talking about affordable units too, but the opposite happens a lot, not just the expiring use, when all of a sudden you get to a threshold that there's no longer the restrictions, and then they can escalate the rent significantly. In some cases, properties will change hands and they may not have escalated the rents consistently over time, and they need to catch up. And when you start, I know lots of the state housing authorities, which is very different than the federal housing authorities, they try to slowly increase that over time, which is what you're talking about, is phasing it. But the residents, because they've been having such a low amount that they have to pay, start to get very upset about, like, why is it more? Why is it going up? But part of that is so that they can survive over time. So I think that's something that we're seeing more and more, that either it's a bad management that isn't increasing rents consistently each year. They're holding them stagnant, which is the worst thing to do. Or it's a switch in ownership and they're saying we need to catch up over time, and we need to make that we need to make those escalations so that we can actually pay bills. So that, I mean, I feel like I'm the affordable housing person, but also there's a lot of these developments that I go into and they don't have enough income to support just their management and utilities. And so they have to do something, or everybody's going to lose their unit because they're going to collapse and they're going to go into foreclosure. So it's the opposite side of things that sometimes we also have to look at. Not necessarily the landlord, but a housing authority or a nonprofit or something like that may have that. Now, Trumbull's a very different town. We don't have a lot of that. So, but it's something to keep in mind,
I think that I guess maybe I'm repeating myself a little bit, but something I said earlier, that when this kind of issue, I don't know that this is going to come to you in the context of a public housing issue, but you will get new purchasers. And I think it's important from your perspective to realize that it's fair for you to assume that a new purchaser of a building that has existing tenants in it is not going to buy the building without having made inquiry as to what are the rents in the building. I mean, it seems to me unimaginable. Somebody's going to buy a building that's filled with tenants and not know what the rents are. So that it's reasonable to say in a town with a fair rent commission, you're not going to be able to do a sudden huge leap in the rents to catch up with the market. And that's presumably a factor that should have been thought about by the person buying the building, that they're going to have to do their budgeting based on an assumption that there will be over time a phase in to get themselves caught up to a market level. And you should be skeptical if someone comes to you and says, well, how am I supposed to make money if I can't move up to a market level right away? Well, the answer is you must have known that when you bought the building. That should have been a part of your planning. And I think it's just important to understand that, so you don't get caught up in that. I've got a right to get up to fair market, a right to get up to current market standards instantly, because they don't, and that's one of the reasons you exist.
I'm gonna have to get off to put my kids to bed, but thank you all so much. I think Rafe, you can stay on.
Okay, I'll stay on as long as you want me. It's I don't know if I'm reaching a point where you're done with questions, but I'm happy to stay.
Guy Rocco, I just had a question. When a new owner takes over, and I'm going to make it hypothetical, but I've seen it actually happen, took over a very large co-op project. They bought out all of the existing owners, but allowed them to stay as tenants going forward. They set new rents that were astronomical compared to what people were used to paying. And my question is this: if a tenant says, I can't afford that, and the landlord says, well, I'm ending the lease as soon as this lease is over, does the tenant then have any recourse with the Fair Rent Commission at the end of that lease period? Or is the landlord within their legal right to say, I've decided I'm not renewing your lease?
The tenant has recourse to the commission. And in fact, that's going to be the most common situation you have, is that the lease is, I mean, you're describing a particular situation where there's a transition in, say, a co-op. But the most common situation is that tenants under a 1-year lease, the lease is expiring, the landlord says, I'm raising the rent by X number of dollars, the tenant files a complaint with the Fair Rent Commission. There's the fact that the lease is expiring is beside the point. I mean, one of the issues that's come up that I think different commissions may have handled in different ways is that it is not unusual for a tenant to be told, if you don't like it, you can move. Either sign the lease or get out. And so the tenant, with no legal advice, with no knowledge of what the alternatives are, signs the lease, complains to his friends. And in a week or week and a half time, somebody says, why don't you go to the Fair Rent Commission? They go. Now, the landlord says, well, you already signed the lease. You've agreed to it. You're bound by it. Well, no, you're not. The Fair Rent Commission has the power to override that. That's the nature of the commission's job, to deal with that issue. There are some commissions, I will tell you, that have said they don't want to take a complaint if the tenant has already signed the lease. But there's nothing in the statute that precludes them from taking that complaint and from deciding that complaint and from enforcing a decision. I'm coming to this from a tenant perspective where we represent low-income tenants. But it's not just low-income tenants, because I've talked to a lot of middle-income tenants as a result of the statute. People don't know what the law is. And a lot of landlords don't know what the law is either. I don't mean to say this is somehow a unique characteristic of tenants. I mean, I've talked to landlords who tell me they get their legal advice from their tenant. Tenant says, I can't do this, so I can't do it. And I say, yes, you can. People get their advice in all sorts of bizarre ways. And the underlying concept really is the tenant has not actually agreed. Even if they've signed a piece of paper, they have not actually agreed to this increase. And I mean, you might, under some circumstances, if the hearing reveals the tenant really fully, knowingly, understandingly felt this was a fair rent increase and signed. Now, 4 months later or something, they're coming back with buyer's remorse. They wish they hadn't signed. You might say, you don't throw the case out without hearing it. But you might say, no, we're not gonna overturn this increase because you really understood what you were doing, and it's now really too late for you to be coming back. Nothing's changed. You could say that, and I'm not saying that would be that wouldn't be an inappropriate decision, but the mere fact that the tenant has signed a lease without more does not mean that, first of all, it doesn't mean you can't take the case. But second of all, it also doesn't mean you can't rule in favor of the tenant or some partial decision in favor of the tenant. That's the power you have under the statute. And you should resist. I encourage you to resist people telling you that you don't have powers, that you think you actually might need to do your job, because it's an advantage or disadvantage of the way the law is written, but the law gives you a lot of discretion. And sometimes a person who's opposing the complainant will try to convince you that you don't have that much discretion or that you don't have that much jurisdiction. I would advise you to resist that. It may be that where the tenant's case is weak, the tenant's going to lose. But that's not the same as you don't have jurisdiction to hear the case and make a decision. Those are two very different things. And because I'm not going to tell you tenants should always win their case. They shouldn't always win their case. But there's very few cases that you shouldn't hear. The biggest problem, I think, in hearing cases is what's been mentioned, which is this borderline where you have a regulated government entity as the landlord, and to what extent can you take action there? Because in effect, it's a situation where there be a superseding statute that controls what the rent is going to be, and can you change that? And the answer may be, typically it would be public housing. The answer may be no. But most other instances, even with government involved, you can act. I mean, I know that 8-30G is a big issue, and it's always been a big issue in Trumbull. Those fall into the category of deed restrictions that are going to expire, or maybe have expired. If people are going to go jacking up the rent by large amounts when the deed restriction expires, you're in a position to say you can't do it all at once. You've got to be reasonable. That's what you are. You're a Fair Rent Commission. And you've got one, whether Trumbull wanted it or not. It's the legislature felt that tenants need to have a place, a vehicle that has the power to address the issue of harsh and unconscionable rent increases. And that it made the choice by saying the larger towns are no longer going to be voluntary. They're going to have to have a vehicle by which the tenant can complain. That's what you're about. Are we out of questions or comments? All right, well, I'm just going to say thank you for having me. I very much enjoy having these conversations. I will tell you that last month I was invited to the Connecticut Property Owners Alliance to talk about fair rent commissions. And I thought it was very nice of them to ask me to come. I mean, clearly I'm coming from a perspective that's different from theirs. But I think that in most towns where there are fair rent commissions, some of the big cities, that the landlord groups are also okay with the commissions. They're not okay with rent control, but they're okay with fair rent commissions. And that's because they're very different from each other. I'd support rent control, but that's not what a fair rent commission is. And that's because the Fair Rent Commission is much more individualized. And it's really applying equity, fairness and equity is, where a rent control board is applying sort of a formula of like you can get a certain return on your investment, and you shouldn't be charging rents that will get you more than that. So it's a market. It's like the Public Utility Control Authority, but Fair Rent Commission is different, and so it's a different. It requires a little bit of a different mindset, and it can go. There are times when under a rent control board, the landlord will be able to raise the rent, and you're going to end up saying no, because it involves a big increase, or it involves poor maintenance, or it involves something that makes you say there's something not right about this. This is just not reasonable. You shouldn't have it at all, or it's too much. Can't do it all at once, or whatever it may be. It's like I bounce it back to you. I mean, I think that's. I think fair rent commissions are really important. Tenants somehow imagine that they can that it's a way of stopping every rent increase, and it is not, because you're considering this from multiple perspectives, but you're looking for reasonable resolutions and the ultimate goal is trying to minimize the forced displacement of tenants by the increase of rents. And we've said many times in talking to this with people, this is not about somebody applying for an apartment saying, gee, I think your rent's too high, I'll go to the Fair Rent Commission. I mean, they got to be a tenant. They can't be an applicant. They got to be a tenant. They got to be there already. And so what you're looking at are either changes, typically a rent increase, or deteriorations in some way that they're not getting. I mean, I know there've been cases where, for example, it's an elevator building and the elevator never works. This is an issue in Rocky Hill. It's a middle income tenant building. The elevator never works. You can't get from the first floor to the fifth floor without having to walk the stairs. And there are people who are old and for whom this is really burdensome. And when they rented, there was a functioning elevator. And now the landlord doesn't seem to want to spend the money to fix the elevator. It's not a code violation. You don't have to have an elevator, or maybe it's forced, I don't know, whatever. But the commission can say, well, you're not giving him an elevator. Yeah, you're not raising the rent, but you're not giving him an elevator. Well, then you can't keep charging that rent. It's just unconscionable to not provide a fundamental service, even though it's not even a code violation. So that's within the scope of what you can do. I mean, I'm just trying to offer you the sort of the range of the things that you can think about.
Well, we thank you for your participation tonight, and you and to Sarah. And I'm sure that as more questions come up, my experience has been that we can find you. So
hey, you can find me. I'm happy to answer questions at any time I can. And I really appreciate your invitation and the opportunity to come and talk. So thank you very much. Shall I sign? Am I okay for me to sign off? Yes.
Nobody's holding you prisoner.
Okay. Again, thanks very much. Yep. Bye.
I don't know how long people want to stay on here. Quick FOI, just a couple of things. One is, I don't know if everybody's gotten a copy of the town's code of ethics, but it's available online. If you haven't gotten a copy, call the first selectman's office, and because everyone is subject to the code of ethics, especially with regard to treatment of the members of the community and conflicts of interest and things like that. So, take a look at it and have it. I won't say memorize it, but have it with you. Just a couple of quick things with regard to FOI. One is what we've seen tonight with a remote meeting. Rules are a little bit different. You can, if the town is in process, Bill Chin is sitting here quietly, but the town is in process of creating a system where we can have a meeting where people are live in the studio and also can pick us up through Zoom. But that's not in place yet, and so we're looking forward to that happening. But most importantly, what people sometimes get caught up in is that the question of having meetings and what constitutes a meeting, and that if you are you can't communicate among yourselves through your internet. Okay, so you can't have a meeting. A meeting has to be called. The meeting has to have an agenda. There have to be minutes of the meeting. And so if five people, if you have a 5-person board with 2 alternates, and 3 of you get together and start discussing the upcoming complaint and how you ought to deal with it and what you want to do and how you view it, et cetera, et cetera, et cetera, you're really having a meeting. And those meetings are meant to take place in public. So be aware of that. Be aware of you can have meetings, or not meetings, but you can have discussions if it's a question of scheduling. And so you learn that there's a complaint has come in. You want to know the availability of members to appear or to come to a meeting at town hall. That's fine. That's a procedural, that's a housekeeping kind of thing, but nothing of substance. If you start getting into matters of substance, this scares everybody all the time when I tell them, but then your personal cell phones become subject to FOI. Okay, your personal emails can become subject to FOI. So don't get yourself into a situation where we get an FOI complaint or an FOI request, and it has to do with correspondence between or among members of the Fair Rent Commission with regard to application such and such. That happens, and in that case, your personal emails would come into play. So just keep that in mind. As time goes on, I'm sure we can have more discussions about it. If you have any questions about what I've said, you can let me know now. But otherwise, I turn it back to Kent. And again, I don't know how much you want to deal with the complaint form now. I know Michelle has collected, it's a large collection of complaint forms that other municipalities have used. And maybe it's the best thing at this point. I think, Michelle, my suggestion would be for you to adopt one now, and if in case a complaint comes in the near future, but you can provide members of the commission with a few of the possibilities so that they can review them and perhaps have another meeting, even another organizational type of meeting prior to any complaint coming in. But we don't have to take that on tonight.
All right. I think the one that we have kind of encompassed everything. Over time, we can make changes to it if it's too much or we're missing something, but we'll probably just change the format of it so it's easier to read, easier to fill out.
Okay, and I don't know if there's obviously there are forms that people can fill out online and submit them online, and I don't know whether that's something we have the capability of doing or not.
I think we can. Maybe we can talk to Bill Chin. We can reach out to him about, I think VOCHI has a possibility of taking online applications and having them sent our way. So that way we can offer the application in different formats for everybody.
I have sort of a weird administrative question because we have a lot of town people with us now, like as far as when we have meetings, as far as staff, Dan, if you're going to be at these meetings, or are we going to have somebody that would take minutes for us, or how do we orchestrate it since we're a new commission? I'm just curious how that's all going to work out, because I'm assuming Rena and Rob aren't going to be every time we meet unless they want to be.
No. No, Michelle is staffing in terms of departments, she's the director of human services and senior center and all that. And Rob and I are supporting her. We get a lot of calls to our office. We'll be directing them. Rob does have a role as designated by, because of our HUD grants and so forth. He is sort of the fair housing officer that surrounds town hall, fair housing. We have a fair housing plan, as you know, that we're required to post and update periodically. And he does have a role by virtue of his position as our town planner. But we're not staffing the commission in any way. That is Michelle and whoever else is doing the minutes and stuff like.
Yes, the answer from my point of view is I assume I'll be the town attorney at most of the meetings, but if not, we would have one of the other town attorneys attend. Cindy for now is Cindy Katsky is your temporary clerk. I won't make it, Cindy, you have to be the permanent clerk, but we will have a clerk. She's taking the minutes, and she'll have the minutes of this meeting. Under rules of freedom of information, the minutes will need to be posted, and we'll get copies out to you. The minutes would be subject to adoption at subsequent meetings, so that there is a process under the Freedom of Information Act to deal with that. All your minutes are going to get posted on the town website, and you can see now the agenda is posted presently. In a few days, the minutes will go up, and whenever minutes go up, they are still subject to final approval by the commission. And yes, Michelle in the Social Services Department, Michelle is the staff person, and complaints that come in will come to Michelle.
Right, we'll be taking the applications and then reaching out to the proper departments if we need any assistance in the process. I'm sure we'll be the ones, I'll work with Cindy to get the letters out, set dates right away for hearings and so on. More than likely, I'll be at the meetings, or staff will absolutely be there, staff members.
Do you think we should approve this, the application, or should we kind of review it, or is this just kind of a standard form that we shouldn't get too concerned about?
Michelle has gone through a lot of different forms that different communities have used, and has basically adopted, unless people have a particular problem with it. I think that becomes our starting point. And as we go along, if people have suggestions of things that you would like to see in the form, or things that you think shouldn't be in the form, you can send those notes to Michelle. Again, as long as we're not, if you send a note to Michelle with regard to a particular item, don't send it to everybody on the commission, because then we're having a meeting. So if you have particular problems, you can communicate with her. If people have problems generally, if there are questions to be posed, another way a lot of commissions do it is have those questions come through the chair of the commission, so that if you have concerns, direct it to the chair, let the chair deal with it. And you will have, if you don't have them already, you'll have everybody's email addresses, so that you can do that. And Janine will be the point person going forward.
I just put my email address in the chat in case anyone needs it.
Okay. If there's nothing else, I think we've exhausted the agenda.
Yeah, I agree. Should we have a motion to adjourn?
It sounds like a good idea.
Motion to adjourn?
I moved.
Is there any objection?
No.
All in favor?
Aye.
Hi.
Good night, everybody. Thank you.
Good night.
Okay.
Thank you.
Good night.